Hi, everyone. Welcome to today's presentation on what to expect in customer arbitrations and litigations being put on by McGuire Woods. My name is Alex Madrid. With me today are my colleagues, Steve Peretz and Natasha Cooper. The three of us are all members of McGuire Woods' broker-dealer investment advisor team, and we all regularly represent broker-dealers in customer arbitrations and litigations, including what we think of as pre-complaint management through arbitration or litigation. And we wanted to convene this time to discuss with you some trends that we are seeing and some predictions we have as a result of the unprecedented conditions that we find ourselves in. Before we get started, I wanted to note that we will be applying for CLE credit for everyone who is in attendance. Our CLE coordinator will be doing so. There is nothing you need to do on your end, and we'll reach out to anyone if there are any additional information that we need. This is the fourth of 5 What to Expect presentations that McGuire Woods is putting on. We hope you've had the chance to attend other ones. Next week, we will be doing our 5th and final presentation focusing on regulation best interest, which went into effect at the end of last month. We hope you have the opportunity to attend that as well. Would like to note for those of you who have not utilized this platform, there is a question and answer feature. You can type questions in at any time. We'll welcome them throughout our presentation, and we will strive to address them either as they arise or at the end, or we'll take them back and come back if needed. But we welcome your questions at any time. We hope we can make this an interactive and entertaining hour. I'd like to start off with just kind of providing you guys with the lay of the land of what we're going to be discussing today. If we could advance to the next slide, please. You should be seeing an agenda for this afternoon's presentation. And really what we're going to do today is divide the presentation into a discussion of what we are thinking of as substantive and procedural issues. So first, substantively, what are the types of claims that we are beginning to see and that we can expect to see as a result of the market volatility that accompanied the pandemic? And our general view is that you're going to see many of the same types of claims that arise in times of severe market volatility, but that the investigation and resolution of these claims are likely to be complicated by the unique circumstances that we're in, which we'll be discussing as we go through these. We also think that it's likely we're going to see some new types of claims that we haven't previously seen before, which we're going to discuss as well. The second thing that we wanted to focus on today is what we are calling the procedural aspects of what to expect. And that's really what we're seeing in the actual FINRA forum when it comes to postponement of arbitrations, the push for virtual hearings, and the many accompanying logistical and other considerations that have arisen as a result of that. So we want to look at this from both sides, both substantively, what type of claims are we seeing and what type of claims can we expect to see? And procedurally, what does the new world of resolving these claims look like? With that, let me move on to the next slide. Certainly, we all know that if history is any guide, times of extreme market volatility and market disruption create risk. They create enforcement risk. They create litigation exposure. And that's been the case going back to the 2008 market crisis, the 2010 flash crash, and certainly the COVID crisis has similarly led to an incredible amount of volatility in the market. We note here that the circuit breakers that were created after the flash crash, or really have been in existence for some time, but came into prominence at the time of the flash crash, have been activated 4 times in 1 month, which was unprecedented. We also note that the Chicago Board Option Exchange's volatility index reached a historic high in March. It continues to move in peaks and valleys. As recently as last month, it was in the 40s. It's now in the high 20s, but is continuing to move around. And the reason we highlight that is that we know that market volatility will almost certainly lead to lawsuits. And that's just, using history as a guide. And so we can expect to see investigations and claims related to a variety of substantive issues, which we're going to touch on. And as I mentioned earlier, it's also creating new procedural complications as to how we resolve these complaints, given the fact that the majority of us are operating still in a work-from-home environment, that physical offices are closed. That creates complications with respect to investigating complaints, responding to complaints, and then ultimately resolving them as needed in a FINRA forum, which we'll get to as well. And one thing we wanted to highlight before we start talking about substantive claims is to note that we look not at any individual complaint as a vacuum. We look at it as part of an overall need to evaluate and monitor for patterns that we're seeing. And what we mean by that is if we see complaints related to particular products that a client has sold, we can expect that we're going to see more of those. Similarly, we can expect that particular sales practices that lead to complaints will create additional issues. So one thing that we wanted to highlight and think about was not just any individual claim in isolation, but how we monitor and manage complaints as a whole. Is there a process in place by which our clients are evaluating the complaints that come in and looking for patterns, looking for red flags, looking to see if particular registered representatives are repeatedly being dinged and subject to complaints, or whether particular products are coming up in customer complaints, that kind of thing. Obviously, of course, as you know, the receipt of a complaint triggers certain requirements under FINRA rules, the requirement to respond within 30 days to a written complaint, and an evaluation of whether that complaint requires disclosure, either on a registered representative's U4 or under FINRA Rule 4530. These are factors that we also think about aside from the substantive merit of a claim or how we're going to resolve that particular claim. We think about, are we responding to that claim in the manner required by FINRA rules, and are we evaluating that claim in terms of what it can tell us with respect to potential red flags or patterns that we need to be aware of. With those preliminary remarks, I'm going to pass it off to my colleague, Steve Perez. Steve is in New York and, like me, is representing broker-dealers right now through this time of crisis. And Steve is going to talk a little bit about some of the substantive claims that we are seeing and can expect to see as a result of the pandemic.
Great, thanks a lot, Alex, and good afternoon, everyone. My name is Steve Perez. Like Alex mentioned, we're seeing, I'm personally handling a lot of pre-litigation complaints, and we're just seeing a lot of them. I spoke with one complaint handler who said in 15 years she's never seen a volume like this. So can we go to the next slide? So, that's not a surprise, right? Past periods of stock losses, stock drops have led to increased claims, particularly when they followed a long bull market like we've been in. And, volatile markets like what Alex described, and also leverage magnify losses. And we also see losses magnified in sectors that are hard hit, places like oil and gas and real estate. And so the stock market drop has brought forward claimants' lawyers who have been on the sidelines for a while. And as Alex said as well, we're seeing both complaints as well as follow-up regulatory investigations triggered by those complaints. I'll also say, we were in a bull market. We saw stock drops right in March. We've seen a rebound, but the COVID crisis is still ongoing, and so the things we're talking about, there's always the potential that we will see further drops, further volatility. So let's go on to the next slide. Okay. So there's a range of claims that we expect to see and are seeing, and we'll go through each in turn. But broadly speaking, we're seeing, the claims we usually see when there's a stock drop, so things around advice. And then we're seeing particular things to the COVID crisis around volatility, and so things like margin calls. And then we think there are also some issues that are some evidentiary issues that the work from home situation so many of us are in impact, and so we'll talk about that throughout this as well. Let's go on to the next slide. So a lot of claims we're seeing have to do with market advice, and so a client calls up, just a traditional thing that you'd expect. A client calls up a financial advisor, back in January, February, says they're concerned, says they want to sell out, liquidate their account, and the financial advisor gives them the advice to hold. And the market rebound and past practice shows that can be good advice, but at the same time, that's hard to believe when you're living through it in March, April, May. And so we're seeing clients make claims around being made whole for losses they suffered after following their financial advisor's advice. We're also seeing, on the flip side of that, situations where financial advisors saw the drop coming, called the clients proactively, talked to them about selling. Their clients sold, got out high, perhaps incurred capital gains in the process. And now we've seen a market rebound, and in some situations, you've got clients who have sold out, incurred capital gains, now see the market back where it was, and are upset about the capital gains they've incurred. And so we're seeing complaints around those capital gains and clients asking to be made whole. We're also seeing in both cases situations where clients are disputing their past discussions with financial advisors. So a client claims that they asked to be sold out or not, and the financial advisor didn't follow their instruction, and as a result, they filed a loss. And then we're seeing claims around trade execution, where in periods of volatility where clients were selling, they thought that they would be selling at a certain point, the market moved from that, and so their expectation about where they were going to execute in the market wasn't met. Let's move on to the next one.
And Steve, this is Alex.
Yeah.
Yeah, I think, one thing that we have noted is that as a result of the work from home environment, it's more difficult at times, or advisors are less cognizant of the need to document carefully client contact, right? When they're in their offices, most broker-dealers utilize a Salesforce notes program or similar, and generally speaking are fairly good about documenting calls with clients, when the call occurred and the substance of what's discussed. And of course, if there is a dispute, usually there is a phone record that can be pulled to demonstrate, when a call occurred. From the work from home environment, of course, that's proven much more complicated, right? Advisors may be calling clients on their cell phones, may not be as carefully documenting the substance of their conversations, may not have access to phone records. I think that's one area where we're already seeing the kind of new work from home dynamic complicating these claims, right?
Yeah, that's a great point. And on that, right, there's also the work from home angle brings in an added twist just around call logs, which obviously, documenting client calls is helpful, but sometimes it can be helpful to point to a call log and show that a financial advisor and a client spoke. And, you know, financial advisors with an office phone that's forwarding, you know, those incoming phone calls will still be logged. But if a financial advisor out of convenience is picking up their phone and making phone calls from their phone as opposed to using their office number, and that cell phone isn't being logged, that call isn't being logged, then there may be evidentiary issues down the road where, you know, we want some documentation, some evidence that a financial advisor and a client spoke and it's not in the call log, and then you're having to explain that. So those, you know, those two sort of best practices, documenting your calls and making sure your calls are logged, are things, always good things to do, but particularly important in this sort of work from home situation and also in a situation with stock drops and stock market volatility. Another thing we're seeing become a theme are suitability issues, and where investments that seem safe in an up or a stable market are being second guessed. And so a few types of clients we're seeing this with: clients with security-backed loans who are particularly susceptible to market volatility, even where the market rebounds because they might have been sold out of their positions. We're seeing complaints from those types of clients. We're also seeing clients may complain that investments they agreed to and were happy with at the time, and in an up market, they're now claiming were unsuitable in retrospect now that they've suffered losses. And you also may see client complaints that they didn't understand their investment and in particular the risk they were taking on due to a lack of disclosure from their financial advisor. And so in all of these cases, the initial suitability determination that was made is going to be focused on by claimants, claimants counsel, and you know, second guessed heavily. Go to the next slide. So how these suitability claims are playing out, we're seeing claims by investors who have reached for yield. So you might have a older or conservative investor who sees the up market, wants to take advantage, and so, you know, is in the moment more willing to take on risk than they are in retrospect, and so they're investing in things with the yield they want, but not fully appreciating, even if it's disclosed to them, the risk they're taking on, and then coming back with complaints. We're also seeing claims by investors in complex products that they didn't understand the products, didn't understand the risk. We're seeing claims based on leverage, as you'd expect in times of volatility, asset-based lending, but particularly margin loans. And then we think a popular theme will be claims of conflict of interest, and in particular around cross-selling of bank products, where claimants counsel try and tie recommendations that financial advisors made to potential compensation benefits that the financial advisor might have received from recommending a bank product. And this is reminiscent of 2008 claims that we saw where clients were taking out home equity loans to invest in the market, and then we saw suitability claims coming out of the housing market crash. Go on to the next slide. So we want to delve a little bit more into margin calls. I mentioned how asset-based lending and margin loans were a particular area where we're seeing suitability claims, and I'm going to turn it over to Alex to talk some around the suitability claims, but also claims based on communication with a client that we're seeing.
Thanks, Steve. And this is continuing, you know, the trend of claims that we're seeing and claims that we can predict will occur as a result of the market volatility. And what I think is notable about both margin call claims, which we're seeing and expect to see more of, and cross-selling claims, is that these are a focus of the regulators as well. And if something is a regulatory target, then it's almost inevitable that it's going to become a litigation target as well. The plaintiff's bar, of course, is well aware of the investor notices that FINRA issues, the regulatory actions that FINRA takes, and just as an area is of interest to a regulator, it's likely also to become a hotspot for customer complaints. And margin calls, I think, is a great example of that. If we rewind to November of last year, FINRA issued an investor alert noting that investor purchase of securities on margin averaged more than $592 billion for the first 10 months of 2019 alone. And FINRA issued the alert based on its concern that, quote, many investors may underestimate the risks of trading on margin and misunderstand the operation of and reason for margin calls. The alert also explained that investors who can't satisfy margin calls can have large portions of their accounts liquidated under unfavorable market conditions, leading to substantial losses. So, clearly the market volatility that we've experienced is going to lead to and has already led to claims from investors who suffered losses due to margin calls. Typically a firm can sell a customer's securities without contacting them. Customers usually not entitled to an extension of a time on a margin call, and they can ultimately, in some cases, lose more money than they deposited into the account in first instance. So as we sit here today, flash forward from November of last year, I really think the investor alert appears prescient in hindsight. Many investors are likely to have suffered significant losses when firms issued margin calls they were unable to meet, resulting in the sale of their securities during the market downturn. And we've already seen claims where investors alleged their brokers did not provide them with sufficient notice of the margin call or misrepresented when the customer's securities would be sold. So just as an example fact pattern, although a margin loan contract typically can state that the broker-dealer may sell securities to meet a margin call without contacting the customer, an investor will claim that her broker gave her the opportunity to meet the margin call, but then sold her securities while she was collecting the necessary funds. And while that claim you may think of as not having legs because of the margin contract and the disclosures contained therein, those claims ultimately do have some persuasive force to them, and arbitrators will often be inclined to view these matters equitably and under the lens of what they view as fair, rather than necessarily, whether a broker's disclosure has covered the conduct at issue. So customers may claim their brokers entered into implied agreements or oral agreements to forego security sales while they collected funds but then broke their agreements. They may allege that they thought they had more time to raise money as an alternative and that was represented to them by their broker. These are the types of margin call claims that can arise and have arisen as a result of the volatility. And one thing to circle back on what Steve said is really documentation is critical in these types of cases. To defend these types of claims, as with suitability or market timing claims, it's absolutely critical that financial advisors document conversations they have with their clients, particularly any discussion that could be implied as a promise to temporarily forego a security sale in advance of an asset liquidation. Switching gears a little bit, I also wanted to talk about another type of claim that is actually not kind of an old suitability claim in new wrapping, but really is the emergence of a new type of claim related specifically to the passage of Regulation Best Interest, which we know went into effect at the end of last month. And really this claim centers around kind of classic theory that a customer claims their broker should have acted more quickly to avoid losses during the market downturn. Regulation Best Interest, like FINRA's suitability rule, does not impose a duty to monitor a retail customer's account The SEC has been quite clear about that. However, if a broker-dealer agrees to provide a retail customer with ongoing monitoring of their investments, then regulation best interest does apply to recommendations as part of that ongoing commitment to monitor the account. And what's important about that is this includes situations where a broker-dealer does not communicate any recommendation to a customer. So that is to say, when your broker just doesn't call you. The SEC has explained that this absence of communication constitutes an implicit recommendation to hold, what we are calling implicit hold claims, and subjects the broker-dealer to the standard of care imposed by regulation best interest. So that is to say, if you're a broker and you commit to ongoing monitoring of your client's account, and then you fail to call your client during a time when the market is either on a downturn or going through a period of extreme volatility, you may face a claim that you implicitly told your client to continue to hold their assets when you shouldn't have. And you can see how difficult that kind of claim can be to defend. Right now, the burden is essentially on you to demonstrate that you made an affirmative decision with respect to this client that it was in their best interest to hold their assets through the period of volatility. And now, you may be thinking, well, this is only going to occur in the cases where the broker makes a commitment to conduct ongoing monitoring. And most brokers wouldn't make that commitment because they wouldn't want to impose upon themselves that kind of duty. Well, Form CRS, which is the relationship summary that is part of best interest, now requires brokers to affirmatively disclose whether or not they're going to offer ongoing monitoring. And so the mere fact that you have this form may lead more brokers to make that commitment, to try to demonstrate to their clients the service that they're giving them. So we may actually see an uptick in these types of claims. In the current context, customers may claim their brokers should have contacted them or contacted them earlier about repositioning their portfolios at the commencement of the market downturn. As part of this claim, they may argue that their brokers agreed to monitor their accounts and thus were required to communicate with them about market events. So again, here, as in so many other cases, the importance of detailed records of customer communications are key. The SEC has noted that this agreement to conduct ongoing monitoring could be made orally and still be enforceable, and that whether that agreement to continue to monitor your client's account after the initial recommendation, whether that agreement exists depends on an inquiry into the facts and circumstances, including what a reasonable retail customer would understand based on the broker's conduct. So you can see how that kind of issue can devolve into a he said, she said, if we don't have clear contemporaneous notes about what has been agreed to with respect to the customer's account on a go-forward basis. This is the type of claim that is really a new type of claim arising out of regulation best interest and the unfortunate fact that Reg BI is going into effect in a time of such market uncertainty. Claim that we want to flag because we do think that we will see these types of claims as well. I'm going to advance to the next slide, and I'm going to turn it over to my colleague, Natasha Cooper, who is based in Atlanta, to talk about senior exploitation claims that we're seeing.
Good afternoon, everyone. My name is Natasha Cooper. So I just wanted to say that we are going to go over this in a high level. We could probably do a whole presentation on senior exploitation and the claims that are going to arise after COVID or during COVID-19 right now. I just want to say as a disclaimer, as we know, it is a little bit misleading to say senior exploitation or elder claims. I think that we all are aware that it is much broader than that right now. It includes anyone over the age of 65, as well as those in a more vulnerable population. So when you think of someone over the age of 65, it's not necessarily the person who is retired, but it could be someone who is still working but is considered a more vulnerable investor. So we have seen an uptick, or states are seeing an uptick in the number of financial exploitation cases in the last 2 to 3 months. There's been talk of this perfect storm scenario that coronavirus has caused. So due to the fact that the senior population or the more vulnerable population has to have more greater social distancing because of the fact that they're vulnerable to coronavirus, there's also this increase of them not necessarily having the access to their financial advisors or their family as much as they would have pre-COVID. Due to these increased vulnerabilities, as I said, states are seeing an uptick in these cases, but necessarily they're not what you may think. I think a lot of folks are saying that there has been increased fraud and attacks, which is true. However, from my experience and what I have seen even pre-COVID, but even right now, is that it does not necessarily always involve a stranger that is preying on the more vulnerable population. In fact, it's usually someone who is the exact opposite. It's someone who is a close relative or someone who has a close personal relationship with the senior investor. So that causes its own unique challenges, and firms should be aware of the fact that even though they may not necessarily be seeing their family members, if someone has a POA or there's other contingencies related to that account, there are vulnerabilities that that senior investor may have by having a close relationship with someone but not necessarily being able to interact or see that. We've also seen issues relating to document authentication. That's been a common theme with these claims. Authenticating documents is already difficult, but then having that in a work-from-home environment has increased the number of claims that we are seeing. For example, with trade instructions, POAs, changes to beneficiaries, there's issues with suspicious signatures, e-signatures, copy and pasting, things of that sort. Additionally, firms are reminded that financial advisors should remain very vigilant right now to unusual transactions. So sudden withdrawals or increased frequency of withdrawals, those are things that have been very common during this time, as well as we've been saying throughout this presentation. One of the key things, and I think we can never say it enough, is to document these conversations. Make sure you are speaking with the right person. Is this a trusted contact person under FINRA Rule 4512? Is this person understanding what they're doing? Is this investor understanding what they're doing? Are you noticing changes in the trading? Are you speaking with them? Are you documenting or emailing them to make sure that you have things intact to confirm that you did pay attention to certain red flags and that you acted on those? Additionally, we know that pre-COVID, this was a huge priority for the regulators. So now it's no surprise that they're increasing their scrutiny as to senior investor complaints that are coming in and the increase of those. When you add in the fact that we are increasingly in a digital age right now, there's a greater need for firms as well as associated persons to remain alert about protecting senior investors from exploitation. Just recently, I actually read an anecdote from the Alabama Securities Commission relating to online schemes. So while we do see sometimes these complaints come in due to a close relative, there are some fraud schemes out there that are increasingly affecting a broader population of people. I think nationwide, it was about 85 investors who were susceptible to what happened. Briefly, what happened was there was an online scheme where it was a reputable online broker, and folks would go online and try to log into their account, and after several attempts, they would receive a help screen button. So you would click on this button for help because you are now logged out of your account or you can't get into your account, and it would then tell you to call this 1-800 number. So investors are calling this 1-800 number due to the fact they can't get into their account, and the person on that line would then tell them to log into their account doing something else. So they would give them another way to get into the account and have that contact information provided to them saying that we can't get in right now due to the fact that our towers are down or something of that effect. So they follow their instructions, they log in this particular way, only to have wires transfers happening instantaneously and taking money out of these investors' accounts. So we've seen issues. I think a lot of them were coming from overseas, but Alabama Securities Commission was discussing the fact that I think it was about $1.2 million, and it's still growing, the investigation to see how this largely impacted, I think, over 84 different victims, and as you can imagine, most of these victims were actually over the age of 65. Additionally, we just wanted to remind you all regarding the Senior Model Act as well as the Senior States Act. It's something that firms can take advantage of in terms of reporting suspected financial exploitation if that is something in your jurisdiction. There is a way for you to report any red flags and to work with the regulator to shield you potentially from liability in any civil or administrative proceedings. And FINRA Rule 2165, as we're aware, also provides firms the ability to place that temporary hold on disbursements of funds or securities from accounts if we reasonably believe that there is financial exploitation occurring or about to occur. And we've also seen very recently as well the revisiting of the potential establishment of the nationwide investor restitution fund. So, you know, they're trying to model after what has already been implemented in Indiana and Montana, so they're revisiting that legislation. But as you can imagine, if there's an increase of potential pool of funds, there may be an increase in claims being brought so that people can eventually recover more money in the end of the day. And I'll turn it over to you, Steve.
Thanks, Natasha. So with all these different claims, I'm going to talk a little bit about some of the best practices that we suggest in defending them. I think, as Alex and Natasha said, right, the best thing is financial advisors documenting their client communications, their client calls, in particular calls where a client and a financial advisor agreed on a course of action, but also to, you know, the senior exploitation issues that Natasha discussed, times, places where financial advisors collected documentation from clients and authenticate how they authenticated those documents. And so just making sure that there's a record of that, because memories fail, and so it's useful down the line to be able to go back and say, this is what was discussed, this is what was agreed to. We'd also suggest, and this goes to Alex's discussion about margin call claims, reviewing client communications with fresh eyes before they go out. And so in the example of margin calls, right, if there are stock letters that are being used, do they speak to all the potential issues that could come up in this sort of volatile situation, and set the appropriate expectation for clients? And then the third point is just to look for potential landmines in the work from home scenario. And so the two we've talked about that, you know, that are helpful, just think through, are calls to clients and from clients being logged in this work from home environment? And then as well, how are you authenticating documents in a work from home environment where you can't see, where you can't necessarily meet with your client, especially if that client is senior, is elderly? You know, how are you doing that? Is there guidance you can offer? And that's the last point, to consider putting out guidance or, you know, advice to your financial advisors so that they're following best practices as well, again, in advance of a claim being made. Go to the next slide. So with that, right, that's the substantive portion of it, but as Alex discussed at the beginning, we also want to talk about, you know, in a situation where everyone is working from home, what does that mean for actually hearing these claims? And so with that, I'm going to turn it over to Alex and Natasha to discuss.
Absolutely. So as the slide indicated, lots of claims. How will they be heard? And we're going to talk now about some of the procedural issues that we're seeing when a claim proceeds to arbitration in FINRA's forum. You know, the first thing to note is that FINRA has administratively postponed all hearings that were scheduled through October 2nd, 2020. And this may be pushed out even further, unfortunately, as we're seeing that the pandemic continues to have a significant impact in certain parts of the country. FINRA has already twice moved back the date through which arbitrations are postponed, October 2nd is the current postponement date, but we can certainly anticipate that that may be pushed back again. And what that is leading to are essentially mass postponements in the FINRA forum, leading to long backlogs. You can imagine cases that were going to be heard in the summer and fall, they're now being administratively postponed. In many cases, due to party unavailability or panelist unavailability, they are being postponed into 2021. I had a hearing that was scheduled to commence next month that is now going to commence in July of 2021. So it's being postponed for a year. One thing to consider, of course, is whether these postponements may create pressure on either side to settle. It's something that we've been discussing with our clients, that it can, in certain cases, provide you with leverage to potentially seek a settlement if you're looking to do so, especially claimants who are in need of funds or were seeking an expedited hearing, which is no longer possible. It can provide you with an opportunity to essentially try to resolve the matter early. By the same token, clients may decide they don't want to continue to have to manage an arbitration through next year and continue to hold witnesses open and available for periods scheduled next year. And so that can increase internal pressure to try to resolve matters rather than have them linger into 2021. Of course, we're seeing, not only the administrative postponement, but also parties moving to postpone of their own accord due to, uncertainties as to when hearings can take place. Something to consider as well, as you're evaluating when your case may go forward. One thing that we've also been seeing in recent months are arbitrators dropping off of panels. Arbitrators tend to be, as we all know, retired professionals. They are in a demographic that is considered at risk during the pandemic, and we have seen a spate of cases where arbitrators have essentially decided to drop out of the arbitration, and we've been required to select replacement arbitrators. Of course, that can pose complications. It can create a situation where what you perceive to be a very favorable panel to you suddenly is not so favorable. Cases that we have that are long running, where we've spent extensive time on pre-hearing conferences and through filings, attempting to educate panelists and essentially prepare them for hearing. That groundwork gets lost when an arbitrator drops out, whether it's because they're no longer comfortable participating due to the pandemic or for any other reason. As you probably know, you don't necessarily have the opportunity to select your replacement arbitrator. In some cases, FINRA will select an arbitrator from the original rankings list and essentially replace them. You have the opportunity to object, but I analogize it to asking the judge to recuse themselves. It's a risky proposition, because if it does not work, you've created a negative impression with that arbitrator and potentially with the panel. So in short, we are seeing mass postponements, mass delays, and we are seeing arbitrators no longer willing to participate in arbitrations. Of course, we don't know why that is, but strongly believe that that's because they no longer want to bear the risk of potentially having to travel or attend an in-person hearing, regardless of when that may occur. So a major issue that we are seeing now is a push towards virtual arbitrations. FINRA has made available a Zoom platform through which the parties may choose to virtually arbitrate their case. And FINRA has made it quite clear that they will only allow the use of Zoom. They do not allow any other video conferencing platform. And they will allow the parties to have a trial run if they so request. But again, there is no opportunity to propose an alternative trial platform. And the reason I bring this up is that some clients actually prohibit the use of Zoom as a matter of company policy. We have a major client whose employees cannot even download Zoom onto their laptops. It's prohibited by the company firewall. And that obviously creates major technical complications if FINRA is requiring the use of Zoom for a virtual arbitration. So we are now thinking about how can we accommodate a Zoom arbitration in these kinds of scenarios, including things like shipping clean laptops to those employees that they can utilize just for the Zoom arbitration, having them use Zoom on their phones or on iPads, things of that nature, because the mandate has been to only utilize Zoom for the hearings. I am noting here that FINRA is not allowing the use of other web conferencing alternatives, as I said. Another important point to make here is that the arbitrator panel can order a hearing to proceed virtually, even if the parties have agreed to postpone. And we've had this occur. So we have a matter that is scheduled for a virtual arbitration commencing in about 2.5 weeks. The parties had reached an agreement to adjourn as we awaited to see what occurs next in this pandemic. And the panel said no. The panel said we're going to proceed on the original date through Zoom. So it's not necessarily up to the parties, even if you've reached an agreement that a Zoom arbitration is not feasible or practical, given technology restrictions, given data privacy concerns, the panel can order it to proceed. So that's something to be aware of as we kind of proceed into this new world. With that said, given that we are now in a world of virtual hearings, I am going to turn it over to Natasha to talk a little bit about how we're preparing for these types of hearings and the kind of concerns that we're hearing clients express and the kind of technical and procedural issues that are arising.
Thanks, Alex. So like Alex mentioned, we don't necessarily have a choice at this point, and I saw we just got a question on that. So FINRA has mandated certain arbitrations to proceed forward and requiring the parties to go forward with a Zoom arbitration, even if they wanted to postpone. That requires unique challenges, as Alex kind of briefly touched on, but we're going to walk through first the data privacy and security concerns. Then we'll talk a little bit about the issues regarding the less control that you have in the hearing process that can, relate to ineffective assistance of counsel. And third, we'll end with best practices for dealing with the challenges related to a virtual Zoom hearing. So data privacy and security concerns, with in-person proceedings now being suspended and remote hearings being more widely encouraged and mandated in certain circumstances, we have concerns about the data privacy as well as the sensitive financial information or personal identifying information that our clients have. It is no secret that there are concerns relating to Zoom, particularly as a virtual platform as compared to others such as WebEx that people may find to be more secure. The Department of Homeland Security, the FBI, and even the CEO of Zoom have all acknowledged that the platform is vulnerable to security breaches as well as hacking. These include security issues not only with having access to the platform, but at times relating to the data and how it's being recorded and stored. While FINRA offers a password for security, Zoom is still not encrypted. So as you can imagine, our clients have voiced concerns about proceeding with Zoom and them not even allowing Zoom platform on their own computers. So we are trying to figure out and navigate the best way to proceed forward while expressing these concerns to FINRA. I personally have seen these attacks while on a call. I had a Zoom conference that another large law firm in New York was putting on for a board that I sit on, and we had a password protected Zoom meeting and everything, and we still were hacked, and there was, a video that came on, but that was due to the fact that they did not disable the screen sharing feature on Zoom. So there are different things that folks can do to potentially make Zoom a little bit safer. I know in our case that Alex and I have, that is proceeding in the next 2 weeks on Zoom. We have already reached out to FINRA to ask them what we can disable, including the file transfer option, as well as the chat feature, the PC remote control, and the document printing and saving feature. So there are different things that we can do preemptively before we go forward with a virtual hearing to communicate with FINRA our concerns and different features that we want disabled before we proceed. So there's less control in the environment when you are virtual. There are due process concerns as well as ineffective assistance of counsel. You have a less ability to prepare your witnesses, and additionally, there's access issues. So we've seen a lot of courts prior to FINRA mandating Zoom arbitrations. We've seen with courts that have gone virtual, there's issues relating to certain witnesses who are international or who are in areas where the broadband or hardware is not as strong. That then relates to connectivity issues. While we can provide them potentially with a computer or iPad, as Alex mentioned, we cannot control necessarily the Wi-Fi that they're on. Maybe you can provide a hotspot, but there are different things that we will have to figure out so that witnesses are not only prepared but also have equal access when presenting presenting for a virtual hearing. Additionally, there's issues relating to the use of documents during the hearings. We have issues relating to rebroadcasting or recording testimony, screenshotting what we have presented, or sharing evidence with someone outside of the internet access. So all of that violates the party and witnesses' privacy rights. So those are also unique challenges that are presented when you go virtual. I'll start speeding up a little bit. I see we're running short on time, but additionally, you lose out on the interaction with the arbitrators. There's lost value in the fact that you are not in person. There's the inability to have those sidebars with just the parties. When you have a witness who is virtually there, you can ask them to disconnect and come back on, but it is cumbersome of a process. Additionally, there's testimony integrity issues, coaching witnesses. I'm sure claimants' counsels will be very creative in ways in which they can, send either a message or even sometimes providing folks with different scripted testimony. So there's things that we don't necessarily have control over when we're not present to see what is going on behind the scenes. Additionally, there's this issue of real-time objections. I saw in Texas they were suggesting that the parties waive real-time objections and save it towards the end. You can imagine the issues with doing that, because once the cat is out the bag, it's really hard to reel it back in. Additionally, the risk of more unexpected disruptions in connectivity and technology issues.
And Natasha, one thing that we've talked about that I think is worth pointing out, and I recognize that we are running short of time, is the way in which a virtual hearing can create effective assistance to counsel issues that an in-person hearing may not. We can imagine a case where your witness is testifying and you are trying to listen in through Zoom so that you can lodge an objection if needed, and you may lose your connection. And it may be some time before anybody realizes that your connection is lost, right? And that can lead your witness to potentially answer questions that you would object to as privileged or otherwise inappropriate.
Absolutely, absolutely. So that leads to our best practices. While certain things are unexpected and we can't anticipate, there are things that you can do to minimize the risk and concerns relating to moving forward with a Zoom arbitration. Number one is test everything. FINRA offers a free and interactive live training webinar. They do provide it to the experts, but the parties will have to specifically request one if they want it. Additionally, the parties should prepare a detailed, mutually agreed upon timeline. I know in our case we have going forward in 2 weeks. It's something that we have discussed in great detail with our client. We are proposing it to the parties where we are going to agree upon the fact that, we have X amount of time to, have openings, and then from there we're going to have scheduled breaks so that the parties know at each given point in time where we're supposed to be, as well as allowing for, I would say, a stricter schedule with our witnesses. Additionally, if you're using hard copy exhibits, while probably not the best thing that most of our clients would want right now, you have to make sure that you allow yourself ample time to get those to the panel as well as the witnesses. I know outside of FedEx and UPS, the United States Postal Service has been reporting a backlog and getting mail out there. So we just advise folks to give yourself ample time to have your exhibits ready after the 20-day, the redacted copies that you're going to be mailing out. Additionally, simplify the trial as much as you can, the arbitration as much as you can. Testimony, obviously, you can't really control the witnesses when they're virtual, but you can avoid them losing steam and the arbitrators losing attention, especially during an 8-hour virtual hearing day. Disconnect any unnecessary devices. So one thing that we discussed, as we said, is access to Wi-Fi. Obviously, one thing you can easily do is just make sure that your connectivity is as strong as you want it to be, your connection. So disconnect, your iPad, your phone, whatever it is that you're not using at that time on the Wi-Fi, as well as addressing any privacy concerns you have with the panel ahead of time. It's something that Alex and I have done. You can draft the letters and get that stuff on the record with your FINRA coordinator for your case, letting them know that you have expressed the privacy concerns, because under the FAA, grounds for vacatur includes them refusing to postpone it, especially if the parties have already stipulated to the fact that they would have preferred to postpone rather than go forward in a virtual setting. Additionally, schedule breakout rooms for those sidebars with your client, potentially not using the Zoom breakout sessions. While Zoom does have that feature, it is still controlled by FINRA. So there's a meeting coordinator who has access to that conversation. So you can imagine the attorney-client privilege concerns that we have with a FINRA coordinator being involved in attorney-client communication in a breakout session. So try to use, whether it is your phone to do a 3-way session with the client, but there are other ways to have sidebars or breakout war room conversations without using the Zoom breakout feature. Additionally, there's other concerns related to the auto transcription feature that Zoom has. That's something, again, to raise as a concern to have it disabled, because Zoom can record conversations and transcribe it while the user is speaking, and the host may not even be aware of that. So that is something, again, to express earlier rather than later. Additionally, as I mentioned, set up a way to communicate with your team independent from that virtual platform, and try to limit distractions. Take away the notifications off your computer. The last thing you need is for the panel to see that email flash across your screen from your client yelling at you when you could have avoided that notification from showing up on Outlook when you're sharing your screen. So there are different things that you can do if forced to proceed, as well as practicing and familiarizing yourself with the technology. So if you have any questions related to proceeding with a Zoom arbitration, feel free to contact myself, Alex, or Steve, or anyone on the McGuire-Woods broker-dealer team.
Thank you so much, Natasha. This is Alex. We are right at our time. We hope that you guys enjoyed the session. We are more than happy to take any of your questions, although we're cognizant that we are now a little bit over the time allotted. You're obviously always welcome to reach out to us to ask any questions. We do have one question from a good friend at Edward Jones asking, given that many courts, including federal appellate courts, mandate virtual hearings, do you see FINRA moving in that direction, i.e. mandating it to clear the backlog? I absolutely think that is a likely possibility. I anticipate that that may occur, that FINRA may say that certain types of claims will proceed by Zoom, much the same way that FINRA has an expedited arbitration process For certain types of claims or claims brought by elderly customers, we can imagine that if the current conditions persist, FINRA may simply mandate that certain types of claims proceed via virtual arbitration rather than continue to be backlogged. It's an excellent question, and I think something that we could definitely anticipate. With that said, let me thank my colleagues, Steve and Natasha, for joining me today, and thank everyone for their time. I hope that this was informative, and we are always available here at McGuire Woods to answer any questions you may have.